Listen, this live stream is for adults only. It's for educational and entertainment purposes. Well, hello there, my friend. Welcome back. It is Monday for you on the live stream. For you on the Rewatch crew, it's whatever day you're at. I don't know. And today we're talking about the case of Maddie Soto, which is super important to all of us, right? We got some updates on the trial of Stephen Stearns, her alleged assayer slash murderer in the first trial. Before we talk about that, though, there's something you and I need to talk about, okay? This day, July 14th, 2025, began the great 2025 Baby Gavin treasure hunt. And from what I can see in the poll that I put up before we went, only about 32% of you, I've incepted myself here. Only like 32% of you or 30% of you are playing the game. Now listen, you got to play the game, okay? If you're into this sort of thing, no pressure, come on. It's for fun. I wanted to make something fun for us to do, okay? So here's the deal. I want to explain the whole shebang, okay? The treasure hunt is a hunt for links. What you do, the first thing you do is you register your email address by clicking on this button. There's a link to this down below, by the way. You click on the register button and you register your email address. It doesn't make you log in, doesn't make you make an account. It just says, what's your email address? What do you want your screen name to be? That sort of thing. It's really easy, okay? And then you'll get clues along the way. The first clue is already there. This is the clue. Before the truth, before the fame, I spoke her tragic, haunting name. A mother's man with charges steep marked the start of secrets deep. The clip still lives where truth first stirred, but not all clues are plainly heard. A trace remains, a subtle twist from lips that rarely talk like this. What you're looking for is you're looking for a place on the internet that clue sends you to. And when you find the right place, there will be a link. Now, it might be a link that says https:// whatever, like that kind of link. Could be an image, could be a word, could be a lot of things. Okay. Every time you find a clue and click on a link, you can it'll take you to a place where you can put in your email address, and that will log that you found that clue, and it will give you the next clue. So far, 4 people have found the link on the first clue, and almost 100 people are playing now. So should be fun. There are 20 clues to find a missing baby Gavin. I don't know. I did this all in my spare time, hoping to give you guys something fun to do. So if it's your sort of thing, please go and do it. And that is all I'll say about. Oh, by the way, if you go to the fish tank, let me bring you over here for a second. If you go to the fish tank, easiest way to find the fish tank is on my website. Click on this little fishy up here. That will take you to the fish tank. Lots of conversations going on over there about the great 2025 treasure hunt, the missing baby Gavin treasure hunt. So I did it for you guys. Hopefully it's fun. Please join us. And if it's not your thing, it's cool. It's totally cool. Okay. Let's get on to Maddie Soto here, okay? Madeline Soto is a 13-year-old girl. She had just turned 13. This was in February of 2024. On the 26th of February 2024, Madeline did not show up for school. Her mother's on-again, off-again boyfriend, a man named Stephen Stearns, this guy right here, claimed that he had taken Madeline to school that morning, but upon investigation, something nefarious was afoot. It did not take long for police to find, according to them, evidence that He had been essaying poor little Madeline for 5 years, doing the quick math. That is since the time she was 8 years old. And it wasn't long after that that her body was discovered and he was charged in her murder. And there are 2 cases against Mr. Stearns right now. The first one is the SA case, where he is facing 60 counts. There's always a link down below, by the way, to the Osceola County courthouse where you can find this stuff. But yeah, he's got 60 counts against him. And look, the jury trial is scheduled for the 22nd of July. Earlier today, there was a hearing. We're going to go over that hearing together. One of the things about me that you guys know is that I am a professional at 2 things. The first thing is I'm a professional waffler. Second thing is I'm a professional quibbler. I have waffled back and forth on whether or not he's going to take this to trial, but I'm coming around to Duty Ron's position where he said he would bet his pension that this would go to trial. And I'm starting to see the wisdom in that, because if Stearns doesn't fight this and he just pleads guilty to it, that is the aggravating factor that brings the DP to the table on the other case. So I think this will go to jury trial. Will it happen on the 22nd? I find that unlikely, but it might. It might happen on the 22nd. Okay. So he had a hearing earlier today. We are going to watch that together. The audio on this, guys, is terrible. Absolutely terrible. It was only coming in on one channel. The mics were cutting in and out. It was very low volume. I didn't want to blast your ears by having you have to turn it up in order to hear what's going on. And then when I come on, like, too much audio. So I have bumped up the audio, but it's still not good. It's not like I'm an audio engineer. And even if I were, crap in, crap out, right? So we're going to watch this together. We're going to check your comments along the way. We're going to comment and pause along the way. And then we're going to have plenty of time to chat. All right. So let's go ahead and get started. Here we go. And mods, blink my light if something goes wrong here, okay?
We're on 3 preliminary trial matters. These hearings are scheduled for 1 hour. Ms. Smith, I don't have a preference on what order we handle your motions. What would you like to address first? Bless you. Mr. Johnson, my apologies.
No problem. Tagging on the first motion, Alex Johnson for the defense. We'd like to address defendant's motion to remove newspapers from courthouse during pendency proceedings.
All right, thank you.
As to
a couple quick things before he really gets into it. Come with me over to Acrobat. There are a couple of motions that they made. Acrobat, for some reason, is doing something wonky with the font, but the first one that they made was a motion for the court to order all media to adhere to the Florida Rule of Judicial Administration. Basically, it's just giving a decorum order to members of the media. It's not that much. Just like, hey, don't, yeah. What is it? Blah, 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 blah. There will be a substantial amount of media coverage in the case. Blah, blah, blah. Deals with blah, blah, blah. Yeah, I mean, it's just a lot of blah, blah, blah. They're just saying, hey, media, behave yourselves, okay? The second one is this one, which is that's a little too close. Let's bring that back. Is the defendant's motion to be free from physical restraint and to use normal writing instruments. Okay, so they want, and I think it's probably for a good reason. They don't want to bias the jury, right? They want Mr. Stearns to not be in a restraint during court proceedings, and they want him to be able to take notes. That's pretty much it. I mean, yeah. So I wanted to give you that preface.
argument for this motion, defense did have pre-marked this morning, and I would move it into evidence as defense exhibit 1. It's been pre-marked as defense exhibit A. A copy of the Osceola News Gazette that was present in the lobby this morning, which directly addresses the Stephen Stearns trial to begin July 22nd on the front page in the newspaper of the whole.
Any objection?
State has no position, Your Honor.
Thanks. We received a defense one for purposes of this hearing. Of course.
Shoot me a message on my website, and I will check. Okay.
This motion, with the recent denial of the motion to continue, the trial is set to begin next week in this courtroom, and as jurors, potential jurors, and jurors that are selected in the trial walk into the courthouse, right in front of security or right beyond security, is
You guys can't see this super chat, but it says if he goes to trial, he gets to see those evil pics one more time. Maybe they might just publish them to the jury and to nobody else. Maybe, and it does suck if he gets to see those.
a slew of newspapers, including newspapers like the Osceola News Gazette, which every time we've had a court appearance, Stephen Stearns has appeared on the front page of the newspaper, and the newspapers constantly indicate that there's both a sex case that is currently pending, which is what we're here for this morning, as well as a capital murder case that is pending as well. So defense is requesting that
It's hard, Patty.
just during the pendency of the trial, not ongoing standing order going forward, that we remove these papers so that way the jurors are potentially tainted as they come in and go about the courthouse.
Understood. All right, the state takes no position. I have confirmed with jury services that jury services do not provide newspapers to potential jurors. The court always has to be careful balancing the right to free press and the right to open and fair jury trials. I do find that should there be newspapers available where the jurors can you give me some guidance as to where this table is downstairs? Is it over by the employee area? Is it where the general public would come in?
It's where the general public comes in. It's so if you're looking at the first floor, there's the area where you go to the elevators, and then there's the mirror there.
Yes.
It's the table's right in front of that
Under
security
the
glass.
progress screens.
Yeah, exactly.
Right. I have inquired as to our court administration who provides the newspapers. I think that's a county function. We have proactively reached out to the county to see if we could suspend the delivery of newspapers during the jury selection process and throughout the trial. So your motion is preliminarily granted. The court will direct the parties that provide the newspapers not to do so during the jury selection or trial process.
Okay, that's pretty simple. During jury selection, the trial process, don't put the papers out in the courthouse. That seems completely reasonable.
Thank you.
Smith?
Yes, Judge. Defenses would next like to proceed on the defense's motion to order all media to adhere to the rules of judicial administration and the administrative order. Essentially, Judge, defense is asking, according to, as the rules require, that the media, and since defense is on the left side of this courtroom and the media is positioned directly behind us, their cameras, intentionally, inadvertently, I'm not saying that they're doing it intentionally, is focused on counsel's table in order to get views of Mr. Stern and things of that nature. So in positioning, counsel's computer screens are in view of the media, so defense is requesting that the media not be allowed to look at, zoom in on, or otherwise project essentially onto counsel's table because of work product and attorney-client confidentiality. I understand that attorney-client confidentiality, we have to essentially affirmatively attempt to protect it. And when we have communications, we do mute the mic. However, because the table is so large and the spacing, defense is just asking that the media not be ordered, not be allowed to zoom in on our computers or our computer screens. Under the administrative order, it says that communications between attorneys and their clients, between counsel and co-counsel, or anything that's held at the bench is required not to be recorded or broadcasted. So the defense's position that anything that is occurring essentially at counsel's table in terms of notes, whether that be handwritten notes or computer screen notes, not be looked at. The defense has taken affirmative steps to have a privacy screen and additionally dimming the lighting on the laptops. However, even with that, it still is viewable for the media, and sitting in court with dim screens and dark lights for multiple hours is going to cause headaches, but also to protect not only Mr. Stearns' confidentiality, but potential other clients' information who we're working on while here in court, if it's just for the media not be allowed to look at and zoom in on computers or counsel's private materials.
Thank you. Stay in your position.
So, I mean, I hate to like restate this because it's pretty darn obvious, but her argument is, hey, I would like an order that media in the gallery not shine or not point their cameras to our work product, our laptops, our table, and so forth. This seems like it could be easily remedied. I mean, the state of Florida is pretty amazing when it comes to openness in public meetings and having the media present in public meetings. It seems like they could just provide video from the court that does not point those things. But I mean, I don't think that this is a request that's unreasonable.
The state doesn't have a position. However, I think if the court is going to issue an order, it needs to be to everybody in the courtroom, not just specifically media personnel.
Yeah, fair enough.
Are you saying
Thank you,
say
Christy.
well in terms of media personnel or anyone not being able to go?
There's a lot of amateur
Yes.
media people that will cover this trial, and they use phones, from my experience in other high-profile trials. So the order should be broad enough that it covers everybody in the courtroom, perhaps even an order that people in the gallery should not be allowed to have their phones out during the trial. Yeah. Sometimes they need daily reminders, sometimes they need multiple daily reminders, but they also focus on the state's computer, and we are obviously against that for the same reasons.
Understood.
And there's no objection to allowing the motion to the defense.
All right. Our relationship with the media has been a good one. They are an essential community partner.
Jennifer, Joy, I think Jennifer, if she's being called as a witness in this case, she won't be in the gallery until after she gives her testimony, after which she would have every right to be there. I don't know if she will.
As I said, the court's going to strive to ensure that this is both an open trial and a fair trial. The days of passing notes back and forth are behind us. A little experience working with each of the attorneys here. I know that your coordination with witnesses, with each other, with presentation, with evidence is highly computerized. The court will expect that the media will comply with Florida Rule of Judicial Administration 2.450, as well as our Administrative Order 2023-23. That order is fairly specific under subsection 2E, indicates that representatives may not cover sidebar or bench conferences, no recordings of conferences or information that occurs between attorneys and their clients, between co-counsel, between the counsel and the presiding judge held at the bench. I've done several trials where the media was involved. The only violations of 2.450 in our administrative order, in my opinion, have been inadvertent. Those inadvertent issues were when a camera operator perhaps went to a wide shot that included faces of the jurors during the trial, or there was a microphone that was inadvertently picking up communications through the microphones at counsel table after the microphones had been apparently muted by the attorneys. These are technical issues. We have a technical team here that the media is absolutely welcome to coordinate with. The administrative rule gives the media an opportunity to meet with our court administration if they have any questions about what the court's expectations will be. The court will expect that the media representatives will be credentialed pursuant to the rule. Non-credentialed members will not be permitted to have out cell phones as members of the general public. So I see no issue with the defense's request to have the media comply with the rules that are already in place, and the motion is granted. If representatives of the media have specific questions, they may contact my office. I will direct them to our court administration personnel. We'll provide a copy of
I don't.
the administrative rule, of which I am sure they are most familiar, and judicial rule, Florida Rule of Judicial Administration 2.45. So the court will expect that that will be scrupulously followed in an effort not to impede the fairness of these proceedings.
And then the last motion is the defense motion to be free from physical restraints as well as utilization of normal items.
Thank you. State, do you anticipate presenting any witnesses in support of restraints?
The state just has one witness, Your Honor.
All right, thank you. I'm ready.
Deputy Richard Rosario.
Thank you.
Okay, so they are moving on to the use of restraints in court portion of this. So the defense has wanted no restraints. If we go over to Acrobat, the defense's motion to be free from physical restraint, to use normal writing instruments. By the way, I don't think this is kind of interesting to me, because anytime I have been in a trial, if a jury is going to be there, the defendant is dressed in like regular clothes that are appropriate for court. They're not in shackles. The jury never sees them in shackles anyway. They're brought over in shackles and so forth, but it's all taken off before the jury sees it. I've never seen a problem with a defendant writing in a notebook to share notes with his or her counsel, but apparently this is a thing in Florida. So let's go ahead and just see what they have to say. Get over here. Here we go.
Please raise your right hand and swear.
Do solemnly swear or
I do.
Apparently this is a deputy sheriff. It's going to testify about restraints.
Good morning. Will you spell your first and last name for the record?
Yes, Ricardo, R-I-C-A-R-D-O. Last name is Rosario, R-O-S-A-R-I-O.
How long have you been employed as a court deputy?
Since March of 2017.
And is your primary assignment to this courtroom that we're actually in right now?
Yes.
Are there policies in place for the use of any type of restraints during a felony criminal trial for an accused?
That's correct.
And how many felony criminal trials have you participated in as a court deputy?
Numerous countless. I can't remember how many
That's fair.
I've worked for.
What type of devices or restraints are available that would be out of the view of members of the jury?
So each courtroom has two. One device is kept downstairs on the first floor, which is a stun cuff, and in the courtrooms we have a leg brace.
How is a leg brace utilized by court deputies during the pendency of a criminal trial?
So a leg brace is essentially a long bar. It has 4 straps, and in the center there's a tab that you can pull so the person can sit down. Otherwise, the bar won't bend. So basically, what happens is when the person sits, it bends, but when they stand up, it just locks, and it prevents the person to run away. Well, they would have to essentially hop away because that leg is stiff.
is the purpose? Let me ask you this. Are there any safety concerns for you as a court deputy in this courtroom should a accused during a criminal trial not be equipped with such a thing as a leg brace?
That's correct. So when any inmate is brought over to the courthouse, they're in restraints, handcuffs, and
Foreshadowing, Ducky.
like chains. When they're brought over for a trial, they are dressed out in proper attire, suit, and at that point, they're in the custody of the sheriff's office, and we have to maintain a level of safety and security for the inmate and as well for everybody else in the courtroom. So that's the reason why we utilize those restraints.
Is there limited staff here at the courthouse for the sheriff's office?
Yeah, so in a perfect day, the felony courtrooms would have 3 deputies. A misdemeanor courtroom would have 2, and civil would have 1. But due to staffing, sometimes people take off or they're sick, and it creates a safety hazard if we're running a high-profile felony case with just 2 deputies. So hence the reason why we use also the device.
Is this device something that is visible to anybody that is looking at the outer appearance of an inmate that's wearing it?
No.
Is this device something that delivers a shock or pulse of electricity or anything like that?
That's correct.
It does or it does not?
It does.
It does. When does that happen?
So, if I may, I have the device in front of me.
Would utilizing the device assist you in explaining how it operates?
Yes, ma'am.
Go ahead.
So, essentially, this is a skunk cuff that's wrapped around a inmate's ankle, and it's tucked away under the clothing. There are 2 metal pieces here that is close to the subject's skin, and the strap is placed accordingly and wrapped not tightly but snug that it won't fall off. The remote is this right here, which is kept at all times with a deputy within the courtroom. Nobody knows who has it. It's hidden discreetly. No one sees it. To activate this cuff, it's a 2-step process. There's on, and then there's fire. So the device.
Shore Life Creations is like, yeah, we want to see him get shocked, and that does tickle me a little bit. And I'm not a person who's really into the whole idea of Schadenfreude. I don't like prison justice, but I do feel it every once in a while, right? And it's one of those things where we'd just be like, oh, please, please, Mr. Stearns, do something in court where you would get shocked on camera. I totally feel that completely.
Won't accidentally fire on itself. It has to have a 2-step button to fire the device.
And the device isn't triggered by movements of an individual or anything like that either?
That's correct.
And is this something that is utilized by court staff in addition to the leg brace that you described?
It's one or the other.
Okay.
Oh, okay.
So there's 2 options that are potentially available to court deputies depending on the scenario.
Correct.
And both of these options are outside the view of anybody that is looking at the outer appearance of an individual as long as they're wearing pants.
Correct. So when we put these devices on the inmate that's scheduled for trial, it's out of the view of the public, it's out of the view of the jurors. No one knows that the person set for trial has it on.
And
Susan, we all feel
let's
that
talk
way.
a little bit about writing utensils. If there is an inmate present in court, are they given a writing utensil?
Yes, they do. They get a flexible pen.
And those flexible pens are made
So the flexible pen is what you guys were talking about in the comments, right? It's a rubber pen. Very cool.
available by court staff to individuals that are participating in the criminal trial process.
Yes.
And what is the purpose of court deputies providing that specific type of writing utensil?
Essentially, the pen, it does write
Thank you, Susan.
well, but is used sort of for a safety purpose in the event that the inmate would like to use it sort of as a weapon. The pen is designed to fold and flex, as opposed to another pen or a big pen or a metal pen that can actually be used as a more deadly device.
It's a safety concern for court deputies.
Yes.
Can I just have a moment?
Of course.
I think all of us would want to just hold that device one time, right? It's like, I don't want to feel that way. I just do. It's pretty funny. The bummer about this is they have to go through this in every trial. Like the defense and the prosecution both know these devices are used. They're acceptable to be used. They're not, in the view of the jury, they, that's funny. I mean, I'm learning about it just now. I mean, I've never seen anything like this, but in fact, that makes me wonder about my local trials. I should call my sheriff buddies and ask them, hey, do you guys use shock belts or some sort of leg restraint or something? Because maybe I'm just completely naive and they've been doing it the whole time. I just didn't know. And if that is the case, then that's a very good
For the
argument
purposes of
for
this
their use.
trial next week, what is the type of restraint that court staff deemed is appropriate for this case?
We will be utilizing the stun cuff, and actually this is a newer version. The older version is a much bigger, broader box. This one is a newer one. So we'll be using this one right here.
Thank you. Defense?
Good morning, deputies.
Good morning.
Now, you talked about the number of deputy or court personnel typically kind of staffed in the courtroom. Are you aware of what arrangements, if any, have been made in terms of staffing for this trial?
None yet.
So you don't know how many deputies potentially would be or won't be in the courtroom?
That's a question above my pay grade. I just will have to figure that one out.
Understood. Now, you talked about two different devices, and you indicated that the stun cuff is the intention in this case, correct?
Yes, ma'am.
And is that because that's generally what's used in this courtroom, or because of what?
99.99% of the time, we always use a stun cuff.
So I want to talk a little bit about the leg brace, since you did talk about that. Now, this leg brace, this is a longer device. It's not as small as the stun cuff, correct?
Right. It's essentially a metal bar. It's pretty long, and it has 4 straps.
And to your knowledge, is that comfortable or uncomfortable?
I would say rather a bit more cumbersome because it's strapped alongside the leg of the person, and if they stretch their leg, it'll snap shut.
So essentially, normal movements could cause it to lock up.
Yeah, as soon as the person stands up, it will lock.
And then the stun cuff, I know you talked about this being a smaller apparatus that goes typically closer to the ankle, correct?
Correct.
And depending on the type of pants or clothing that is worn by the person, that could affect the visibility of the item.
Yes. So normally, male inmates will always have long pants, and the cuffs go right around it, so you really can't see it.
But the pants legs would have to be wide enough to kind of flow and fall over so it wouldn't be visible, correct?
Yes, and we always apply to the right leg, which is furthest away from the jurors.
And typically when sitting down, your pants often rise, generally speaking, correct?
Yes.
And so if the pants are shorter, then the stun cuff at that point would be visible likely?
I don't know why she's even arguing about this. I honestly have no. Come on.
And those straps, I know we saw kind of like the strap that goes around. Where does the extra, so to speak?
By the way, I noticed that the probes on that leg device, on the ankle device, were round, and he just said that they're near the skin. That means that they have to have such high voltage that it would arc to the skin, which, I mean, in my layman's opinion, that's a butt ton of voltage. It may not be a lot of current, but it's a lot of voltage. So, I mean, wow. Because typically, like a contact stun gun or even like a taser, requires probes that either penetrate or touch, and that one didn't even look like they touched. That's yeah, that's some medieval stuff right there.
That tuck in, or does it tuck in somewhere?
So when you apply this apparatus, it wraps around and then the strap goes through here so it holds it down.
Okay. So similar to a belt, you know how when you use a belt and you have the extra.
So this is Stephen Stern's public defender. I think that she has done a terrific job in this, by the way. She's made some terrific arguments, even ones that she's lost. I thought that she's done really well at. I think she might be making this argument because it's almost required that an argument be made. Like the law requires that this argument be made, that this hearing take place.
Where would you tuck in, or where does that extra strap go?
It just remains there and it just folds in.
So would it be secured, or would it be kind of sticking out?
Just stick it out right. I mean, you would really have to look for it to find it.
Okay. Now you talked about the two-step process with that remote for the stun cuff. I believe you said it was an on and a fire, correct? So does that mean that once the stun cuff is applied?
So, Short Life Creations, I totally get your what you're saying here. The issue is whether or not the jury could be swayed one way or the other by how he is treated in court. That's the main issue. It's not whether he's happy, whether his lawyers are happy, or anything like that. It's about will jurors be swayed in their thinking about his innocence or guilt based on how he is treated by the state. And that's an important thing.
Is typically automatically in that on position, and then you just have to go to step 2 or something else.
By the way, you guys just saw me be a professional waffler there. That's who I am.
The apparatus is turned on, so it's always going to be on. But to fire it, you have to press the on button again and then press fire.
Okay. And those two buttons are, I don't want to assume, are they next to each other on the remote, or are they two different areas of the remote?
Yeah, so the on, and then you would have to switch over to fire.
So one side is on and one side is fire?
Right.
And I believe you said that typically one deputy has it, maybe between the 3 of you or 2 of you, depending on how many are in here. You guys would know, but none of the other court
Nobody
personnel.
knows who has it.
Just the person who has it, I assume?
Yes.
So you would know that you don't have it, and so if there's only 2 of you, by process of elimination, the other person would have it.
Correct. So essentially, when we do a courtroom operation, each deputy has an assignment. One is for the inmate, one is for the jurors, and one is for the security of everybody else.
Now let's talk about the writing utensil. You talked about this flex pen or the flexi pen, about how it's designed to collapse in on itself. Now this pen still does have a normal point, that a ballpoint pen would have, correct?
Right.
Would the utilization of, say, a felt pen be something that could potentially not be a safety measure?
Well, we're not really concerned about the tip of the pen. We're concerned more of the body of the pen. more firm structure, can be used as a stabbing type weapon.
And with, are you familiar with felt pens? Okay. Now with those, typically that point, it's soft, correct?
Yes.
And with the flexi pens, and even with the stun cuff, those are only utilized for people who are in custody, correct?
Correct.
If an inmate who wasn't in custody was sitting at counsel table, he
This
wouldn't
is a
have
good
to have
argument
on,
she's
or
making.
she would not have to have on a stun cuff or a leg brace, correct?
Correct.
And writing utensil. If a person was out of custody, they also would not have to use a flexi pen, correct?
We normally give them flex pens as well.
Even a person who's out of custody?
Yes.
In terms of,
The argument she's making is that if he's the only one in court using a flexi pen, will he be, again, will it be noticed by the jury? Will they say, oh, he must be guilty because they won't let him have pointy, stabby things? You know, this is a pretty good argument. She ultimately loses, but, well, no, she ultimately wins on this, I think. Anyway.
I know you talked a lot about safety. Are you aware of any attempted escapes or anything like that for Mr. Stearns?
Of Mr. Stearns or any other inmate?
Mr. Stearns specifically.
No.
Can I have a moment, Judge? Have you had any defendants complain about the comfort of the stun cuff or the leg brace?
No, so essentially, if the stun cuff, we put it not too tight, so it doesn't impede with blood flow or anything, or potentially injury, but it is placed snug, so this way it won't slip out. So, but we've not had complaints.
So no one's ever complained about like itching or discomfort or rubbing?
No.
What about with the leg brace?
I've not had much use of the leg brace. So the leg brace, to be clear, is if the courthouse has a number of jury trials of that day, and these stun cuffs are placed in the chargers respectively downstairs in our office, and whoever gets there first just grabs them, then we just have to go to the leg brace because there's no more stun cuffs.
Okay. And do you know how many stun cuffs the sheriff's office has in terms of within the courthouse?
Well, I believe we have 4.
And I know you mentioned staffing and things like that haven't been addressed yet, so you're not necessarily sure of the logistics of what potential other trials might be needing them?
So normally with big high-profile cases, there's a meeting with the judge, court, jury services, and sometimes our supervisors will be there just for logistics.
Okay. But I believe you had said that at this point, you're not sure if it's happened or you weren't a party to it.
Exactly. I have no knowledge of anything yet.
And then one more moment, Judge.
Hey guys, I'm cheating and I'm looking at the standings on the great 2025 Baby Gavin treasure hunt.
You mentioned not being aware of any like, escape attempts or anything like that. Are you aware of
8
any
people have found the first
violent
clue.
outbursts or any propensity for violence that Mr. Stearns has demonstrated during the course of his incarceration?
No, he's been quite compliant with everything we tell him to do, as far as just remain seated and come this way and sit down. He's not giving us a problem yet.
No further questions, Judge.
He hasn't given us a problem yet. Ha. 8 people are in the lead, having solved clue number 1.
Additional witnesses or others?
No, Your Honor.
Thank you.
I am feeling better. I'm coughing very little now. Thank you.
Yes,
for that.
Judge. Defense in this case is asking that Mr. Stearns be free of the rule as either use of the leg brace or the stun cuff, and we're also asking for the use of a regular writing utensil, specifically maybe a belt pen in this case.
Why? Why do you care what writing utensil he is?
Judge, in prior experience, the flexi pens, they often skip, they often don't have ink, or they don't write well. So when a time is intended to communicate, especially in an attempt to not use the microphone so that counsel can pay attention to the questions that are being asked, having a utensil that writes and functions easily and freely as opposed to having to stop, well, not necessarily stop the proceedings, but trying to get a deputy's attention to get us another flex pen while we're also trying to watch what is being presented, listen for objections or making necessary objections. Essentially, it's a distraction if we're having to make sure that his pen is working, he's able to communicate with us, or being able to read it if it's skipping, so we're trying to figure out essentially what are the holes in the bubbles of what he's writing. Generally speaking, the flex pens in the past haven't been the best. And I understand, kind of like a regular pen, you grab one out of the box, if it works good, it works good. So we're asking for like a felt tip, and I understand the deputy's testimony in terms of the safety concern. It's defense's position that the use of a felt tip pen, being as a soft tip, it's essentially a marker, we would give it to him without the cap, would be.
That's an interesting argument. She's like, well, you know, it could be interruptive during proceedings. The plexi pen doesn't work really well. We have to be distracted. That's an interesting argument, and I kind of feel like they're talking. I loved how the judge was like, what do you care what kind of writing utensil he has? Like the judge wasn't even getting it, but okay. I mean, it's an argument.
Sufficient, he would be able to write and communicate with us easily and effortlessly without having to worry about him stopping or not working and things of that nature. So we're asking for the use of a regular writing utensil, and we're proposing a felt tip pen.
Austin, guys, I'm going to keep plugging this. Austin, I'm glad you're here. First of all, welcome. The treasure hunt is over on gavinfish.com. There's a link down in the description below. It's just something we're doing for fun. There are prizes, and if I can get sponsors, man, I'll make better prizes. But they're prizes. Yeah. So go check it out. I mean, look at this. Just look at this. Guys, I'm interrupting the video. But the treasure hunt's gonna be fun. And like I said, we've got 8 people that have solved the first clue. They're 5% down the road, which is pretty cool. Okay, here we go. I will stop.
To utilize. And then in terms of the restraints, again, we're asking for Mr. Stearns to be free of physical restraint. I understand the policy of the sheriff's office and things of that nature. However, it's supposed to be looked at as a case-by-case basis, not a general policy that applies across the board. There's been no testimony of any escape attempts, any propensity for violence during the course of incarceration. However, the deputy actually testified to the opposite, that Mr. Stearns has been compliant, that he listens, follows directions, does what it is that is asked. So, and I understand the staffing issue. However, at this point, they're not aware of the number of deputies that will or won't be in the courtroom anyways. So the defense is asking Mr. Stearns to be free of physical restraints, because if he was out of custody in this case, he would not have physical restraints. I know the deputy testified that typically people who are out of custody also use flex pens. That hasn't generally been my experience in this courtroom, but that could have changed since the last time I've done a trial here in this courtroom. So the defense is asking that Mr. Stearns be free of physical restraints and be able to utilize regular writing specifically of
She's a fast talker.
Yes, Your Honor, the state provided testimony through Deputy Rosario, who testified as to what type of restraint would be used for this trial should the court deny the motion. The process of utilizing that stun cuff. Also, he testified as to any potential safety concerns with this being a felony criminal trial, and also any safety concerns with the type of writing utensil that was provided. The state would request that the court deny the defense's motion.
Thanks. Can I see one of the safety pins, please? Do we have one?
Yeah, she really does. She speaks very quickly. Virginia.
All right, for purposes of the record, I'm holding one of the safety pins.
Virginia, I'm sorry, I just interrupt. That's what I do. It's my channel. I do it. If it bothers you, I totally get it. It's totally cool. I'm not for you. I'm not for everybody. But yeah, I interrupt. That's what I do.
Basically, the internal tube that has the ink in it, and it's surrounded by a clear rubber tube, fairly flexible. They're also about 3 inches long. Look substantially different than the writing instruments that the attorneys would be using.
Yeah, he's considering it. He's like,
All right, we're not, on the Shackle motion, we're not in uncharted territory. There's some case law that applies to this case. Weaver v. State, 894 second 178. It's a Supreme Court case from 2004. In that case, there was a defendant that was charged with serious crime.
I'll talk to you offline on him.
Appeal. They took issue with the electronic restraining device, a belt in that case. In that case, the defense cited United States v. Durham. That's 287 Federal 3rd, 1297, 11th Circuit, 2002 case. In that case, the 11th Circuit indicated that a stun belt poses a greater threat to the dignity of the courtroom than shackles. That was based on a potential that it is reasonable to assume that much of a defendant's focus and attention when wearing a stun belt is occupied by anxiety over a possible triggering of the belt. Interestingly, in that case, there was an accidental discharge of the stun belt that occurred outside of the presence of the jury. The Florida Supreme Court in that case found that the judge's discretion in exercising of the discretion to wear a stun belt was warranted. However, in that case, the defendant was pro se and was permitted freedom of movement about the courtroom. So the court in the Weaver case surmised that there was no lesser alternative other than the stun belt to allow freedom of movement, as well as accomplishing the concerns, which was a concern regarding escape or proximity to the attorneys, the jury, and the court. In this case, we do have an alternative. The court has never had an accidental discharge of the stun cuff. The court has not before had any indications that the stun cuff was visible to the jury. The court before has never been presented with the argument that a defendant was preoccupied by the wearing of the stun
That's
cuff.
interesting.
In this case, Mr. Stearns will not have freedom of movement in the courtroom. The use of the leg brace, the court as well has never received a complaint about the comfort of a leg brace. Because Mr. Stearns will not have freedom of movement, the court's heard no prejudice to the fair trial proceeding to have Mr. Stearns wear a leg brace that would, in the unlikely event that he not be compliant and stand up and make an effort to exit the courtroom, that would lock and give the resources that are on hand an opportunity to intervene. The court understands that these matters should be considered on a case-by-case basis. The court can see no prejudice. The device will not be visible. The court has not before received a complaint about the comfort of that particular device, and the fact that Mr. Stearns will not be permitted to move about the courtroom anyway. The court can't find that would be prejudicial, and the court finds that a consideration of, due to the layout of this courtroom, its proximity to the jury, its proximity to the exit of the courtroom, and the severity of the allegations and the emotional nature of what is surely to be presented, that a leg brace is warranted and will be ordered to be implemented while he is present in the courtroom.
A leg
We
brace.
also have a private area that can be outfitted, and I'll address continuing concerns moving forward.
He wants a leg brace, not the electric.
That is going to
Cuff.
conclude our hearing. Use of the pen. He'll be provided with a felt pen. I'm going to ask that that be specific to Mr. Stearns. That will remain in the courtroom. when he comes and goes, he can have the flex pen in the back if he needs to write notes while we are not present in front of the jury. The court understands the concerns of the deputies.
Did I get that right? He just ordered the leg brace, the locking leg brace, not the electric stun cuff, right? Did I get that right? That's what he said. Let me check the order. Give me a second. Let me check this order. Testified. It doesn't say specifically, but I think he just said he wants the leg brace. So not a stun belt, not a stun cuff. Interesting.
Sympathize with that. The layout or the construction of the flex pen, it's different than the construction of ordinary pens. I fear that it may create the question in the mind of the jury as to his incarcerative status.
Good.
That would be prejudicial. So he'll be provided with a felt pen, and he'll just leave it on the table. Any further?
Just a logistical matter, Your Honor. We are intending to bring,
Guys, that means that we don't have the opportunity to do some sort of hacking of the electrical signal to try to get our key fobs to stun him, which I do not approve of. I do not approve of that at all. Not even thinking that. I don't even approve of that. But we don't get that opportunity. So the hackers among you, I'm sorry. It is an analog device that will be strapped to his leg. Very interesting. So stabby felt tip pen and a leg brace as confirmed by Watercolor Dog.
a whiteboard or TV for the presentation of evidence next week. So as to
I'll check it out.
As much as we can, the sensitive nature of the material that we must show to the jury. So logistically, I just wanted to bring it to the court and defense's attention.
Will this be on a cart?
Yes, it's on wheels.
So what do you need from me? Place to put it?
We can bring it up when we are intending to use it. I just wanted the court to know, because I know sometimes the court is going to need to get down to view the evidence. I anticipate that we'll put it over closer to the jury so that the family, who is also potentially going to be present, will not have view of it. Also, other individuals in the courtroom.
Understood. Thanks, I understand.
Addressing
Evidence is obviously of a sensitive nature.
addressing the viewability of the evidence. So, yeah, that's good. Nobody in the courtroom should be able to see it. She said other individuals in the courtroom. I think that also includes Mr. Stearns. Very good.
Is unlawful in and of itself. I am happy to provide the courtroom on the afternoon of the 21st if you want to wheel your equipment up or have your tech folks do so. Gameplay how you would like to present that. The attorneys will obviously have an opportunity to move about the courtroom as they need to observe evidence. Mr. Stearns also has a right to view the evidence being considered against him. So we're going to have to accommodate all of those competing interests to ensure that the jury has an opportunity to review the evidence that the state intends to review.
He gets to view the
Does
evidence.
the state intend to close the courtroom or request a closure of the courtroom during the presentation of any testimony or evidence?
Interesting question here. They're like, haven't considered it. Let's whisper. Yes, we would like a closed court, please.
Your Honor, that is the intention of utilizing the whiteboards, that only individuals that have to view the content. We do not have a surviving victim to testify in this case, so I don't know that we necessarily have a right to close the courtroom for any of the proceedings. However, due to the sensitive nature of the material that is going to be presented in the form of actual videos and photos and things, the state intends to utilize the whiteboard in an effort to prevent other individuals that do not need to see that evidence.
Anticipated some of the evidence was multimedia, and I didn't know whether it had sound or what this position was going to be.
There are, I believe, 5 counts that are video with sound.
If the state makes a determination that closure of the courtroom is warranted pursuant to statute and victim rights, Marcy's law, I'll ask that's your intention. You present that in writing. We'll address that. Give the defense an opportunity to weigh in on that request.
Yes, sir.
Thank you. Defense.
I believe those are all the witnesses.
Thank you. Right, as I said, the court will make itself available for the rest of this week and on Monday for access to the courtroom. If you have specialized concerns, equipment concerns, please be proactive in asking in advance and resolving those issues with court staff prior to jury selection beginning on Tuesday, the 22nd.
Next Tuesday.
Okay.
Holy cow. Wow.
Are you going to provide the film?
Yes, Judge, we can provide those.
All right, so we'll run those, just bring them in and let the judges take a look.
It's a court preference. Blue or black, color preference.
All right, that is the end of it. We're going to bring up Maddie's photo. I'm going to go ahead and pause that so we don't have to listen to it. Couple of questions that you guys had. What is up with the volume fading in and out? That is the way that the volume came from the court. It's like I did my very best to make it so that we could hear it. It was really low in the actual broadcast, so I did the best that I could. So Broke Stacker says, do the jurors see CSAM? It appears the answer is yes. Yes, they will. Mr. Stearns, I believe, will also see it. Are they going to bring these same arguments for the murder case? Possibly. I don't know. It's the same legal team. I'd imagine they will have some of the same, legal questions. Though it's a different case, and after this case is finished, it's going to determine a lot of things in the second case. How much did the court pay for the stooped allowances for Stephen Stearns? Stooped allowances. I don't know, but it's his legal right here in the United States. He gets that. He has that right, and so that's the way it is. Tina says, from what I understand, being that she is a minor, the photos will be somewhat redacted for the jury. Do I have that correct? I don't know, but I don't think you do. They show graphic evidence when there is such evidence to the jury. It's one of the things that we should be very grateful to jurors who serve in cases like these. Again, there was a case here in Western Pennsylvania that I covered for my day job that the victim was 2 years old, and it was graphic and published to the court. It wasn't SA in that one, but I don't imagine that they will cover up the evidence. I think the jury has to be presented with that evidence. And I think that evidence will include the photographs that they took of him, in this session. I think it'll include stuff like that. So they will show probably some of the CSAM, and then they will show the matching parts of Stephen Stearns. I think they have to do that in order to prove things to the court. And so, yeah, I doubt it. I don't know that though. I just doubt it. Great question. Great question. Let's see. I am appreciated. Thank you. I appreciate you. Now he definitely won't take a plea deal. He knows he gets to see those photos and videos. Yeah, I think that Duty Ron was correct when he said on my channel that he would vote, or he would bet his pension that he wouldn't take a plea deal on this one. I mean, there's no upside to him taking a plea deal on this one, unless the offer is really good from the prosecution. So I guess we'll see what the offer is. Maybe does the prosecution take DP off the table in the murder trial? It's possible, and I would be okay with it if that happened. I would. It again. There's no justice here, everybody. We all understand that, right? There's no justice here. Justice would be Maddie being alive, having not spent 5 years being a victim of this predator. That would be justice. Short of that, they can't get justice. They can only get as close as they can. So I guess I would be okay if he pleaded guilty to this, to get DP off the table, spend the rest of his life in prison, sucking on root beer barrels and eating canned cod or whatever it is. I would be okay with that. I'd be much happier with the DP, definitely. But yeah, let's see. Sandra says the state attorney said there are 5 videos with sound. Yeah, I think they will watch them. Jerry, I'm glad you were on your first live. Thanks for being here. V from Down Under, I think he will plea after this case. Yeah, I think it's more likely that he pleas in the murder case than in this one. I agree with you. But again, I reserve my right to be a professional waffler. That's funny. Yeah. Okay. Before we go, because we've already gone kind of long, let's just real quick, head on over and check in on the great 2025 Baby Gavin treasure hunt. Guys, this is just for fun. There are prizes in the form of gift card or gift codes to my merch store. But also don't forget, you get bragging rights if you solve this. There are 20 clues, and I made it so that it might take months. However, I also have a very simple mind, and you guys are probably way smarter than me, so it might just take a couple days. But so far, let's refresh this real quick. So far, 10 people 10 people have solved clue number 1 out of 20. They are now on clue 2 of 20. Oh, and here's the deal. There are enough prizes for 14 people, but as Autumn said, you could donate. You could donate to the prize package, and I could open it up to more winners. Sure. And I will, maybe what I could do is I could just create a PO box, and there, there could be, you could reach out to me and say, I want to donate something, and I could send you the PO box, something like that. But yeah, I mean, if this goes as long as I think it will go, we have time for that. And if you guys end up really liking this, how many people are signed up now? How many people are signed up? Let's see. Looks like we've got 129 people that are signed up. So, yeah, and if you don't see that your name is showing up on this list, it just occurred to me. Um, the system doesn't have a real sort order besides when people solve a clue. So you could be going from page to page and not seeing your name, or seeing your what is it, your screen name. But if you try to re-register and it says, "Hey, it's there," don't worry, it's there. Okay. And I could what I should do is, that's a little bug that I should fix for sure. But anyway, we just want to have a good time. I mean, true crime is interesting. We take the opportunity to learn while we're doing it. Um, but maybe we can have a little fun too. Take the crime seriously, take the victims the most seriously, but not take ourselves seriously, and maybe have a little bit of fun. So please join us in the great 2025 Baby Gavin treasure hunt. Click on this little icon on my website, and that will take you to ye ol' fish tank where we hang out and talk about all things true crime. That is a great place to clan up, by the way. Find people that might be able to help you along the way, because I know some of you are confused by that clue, but 10 people have got it figured out. So maybe you can clan up over here on the fish tank. With that, guys, thanks so much for spending your time with me tonight. I'm so glad that you did. We will see you on the next one. We always do this Monday through Friday, 7:30 p.m. Eastern. And until then, I bid you adieu. Take care of yourselves. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.